Yes, welcome to the No Day Project live from the fortified compound in Mesa, Arizona. It is episode 126 of the No Stay Project, which just happens to have fallen on the 18th anniversary of 9/11. My gosh, it's been 18 years already. Wow. And I can at least speak as somebody who lived through the horrors that are known as the Bush administration. But we'll get to that. Appreciate everyone tuning in today for the big show. If you'd like to help support the show, it is definitely appreciated and needed. You can do it at markstevens.sells.com. That's SELZ, markstevens.sells.com, and also at markstevens.net, where if you are being attacked by a bureaucrat, you want to learn how to more effectively defend yourself against these attacks, especially these code violations. And we have a full model for being able to do that has been replicated, where the success has been replicated many times, that you can see at markstevens.net under the success stories. And yes, I know every week I just keep getting more behind. So I'm going to I'll have it up. I won't be doing a live show on Saturday. So I'm hoping it's a really busy week. I have got these videos I said I'm going to get up there. I've got 3 videos I need to get done. Hopefully I'll get them real soon. I will be back on a regular schedule Monday and Saturday every week after this Saturday. So, although we've had 3 shows in a row, and I don't think we've even had a tech issue in 3 shows in a row. So, we got that going for us, which is nice, which is pretty nice. You want to join me on the big show? It's I didn't even open up the caller line yet. Look at that. It's just one of those days. We're not going to have a tech issue. It's not a tech issue. So we'll just get up over here. I'll have to mute out my caller line for now. And see. Yeah, wow. We already have a line of calls. I got so much to get to, but I do appreciate people calling in. The number, of course, is 218-632-9399, 218-632-9399. And so I want to talk about 9/11. We're going to talk about that. I'm going to get to the calls. I want to just address some I shouldn't do this, but some people may be convinced by this, so I want to point this out. This is a criticism that's something that just goes on and on and on and on and on. My gosh, it never stops. I have been very clear about this point, and for some reason, I don't know, maybe this is why I say troll, because anybody who listens to the show should realize that this criticism is completely off base. Poor Mark still doesn't grasp that prima facie evidence which meets the prima facie burden establishes a rebuttable presumption of jurisdiction and facts that are challenged at trial only. An arraignment is not an evidentiary hearing. Duh. Okay. Thank you, Captain Obvious. Maybe there was 2 or 3 people that were not familiar with that. Not something that I've ever gotten confused on the show. It's not an evidentiary hearing, so no evidence beyond prima facie is required. Yeah, that pretty much I know. I talk about last week I talk about the difference between burdens of proof. I even said, up until the moment you start the trial, it's only a prima facie burden. I know. Who watches every minute of my show just to post the same off-point, incorrect kind of criticism? Evidence that proves jurisdiction beyond a reasonable doubt is a trial issue. Yeah, it's not a trial issue only, though. That's why the judge will say jurisdiction's a trial issue. No, he's saying jurisdiction. He's trying to make it look like jurisdiction is a trial issue only. And that's where I have the problem. When the judge wants to shut down a jurisdictional challenge and say that you can only do that at trial. That's why I use the example of if you sue a judge or prosecutor. They're not going to argue jurisdiction at trial because it's not a trial issue only. Poor Mark still doesn't grasp. See, what's missing here, and it says prima facie evidence which meets the prima facie burden. My whole position here is that it does not meet the prima facie burden. I'm saying that, and I've gotten quite a few bureaucrats on record agreeing with this, that your physical location does not prove the Constitution codes apply. It's not sufficient evidence. And therefore, since it's not sufficient evidence, it's not meeting a prima facie burden on jurisdiction, personal and subject matter. I can't make this any easier. So hopefully nobody has been misled by this. I've been very clear about this, and you can challenge the facts, the sufficiency of the facts at pretrial, during the pretrial, even before the arraignment, because in California, under the Criminal Code, Section 1001, which is in my demur template, their own law sets forth that demur is proper if the facts are insufficient. So this is, I'm pretty sure I shouldn't, again, I shouldn't have even have addressed this, because it's just, at this point, it's just trolling. But again, I do grasp in prima facie evidence meets the burden. Yeah. Again, the dispute is that it does not meet the burden, which is why we're challenging it prior to trial, which okay, I wish that issue was, I think for regular listeners and people who even knew, that issue has been put to rest. Again, I cover that every single show. So if I'm wrong, somebody call up and set me straight. Obviously, the one who left that comment will never call the show and confront me in real time. But if you're an honest critic and and there's something I'm saying on the show, I've got it wrong, or the logic is wrong and the facts are wrong, 218-632-9399. The passcode is 2020 with the #. So we got a lot of calls. So I will get to the 9/11 stuff after the calls. And all of the calls could be about 9/11 also. So that's not a problem over there. So we got Ted in Washington back. Ted, welcome back to the show.
Hi, Mark. I'm back. Thank you for taking my call.
Good to hear from you again. You got good news?
It's still pending. I don't even have a court date yet. Just want to touch base, and I will be following up with a media rep request as soon as I have a court date. But I wanted to call on a couple of points. What do you think about filing a judicial conduct complaint for a judge that doesn't even show up on time? The whole peanut gallery is obligated to be there at 8:30, but yet she publicly logs in 11 minutes later and just a quick superficial, "Oh, I apologize." And then she nails 8 people for failure to appear.
Did you actually did you see that with those kind of numbers? Did you witness that?
Yes.
Wow.
Yes, absolutely. And I wrote down the names of the people that had failure to appear. I was practicing being a court watcher this week.
Good. If it's less than 15 minutes, I don't see that. Look, I get that. How dare you force everyone to be here under threat of jail, and then you just waltz in 10 or so minutes late and then charge other people with failure to appear. I don't think a judicial conduct commission complaint would go anywhere. That's something. Okay. I think they would blow that off, even if you had all the people, the poor victims of that, sign off on it. They just feel like, well, court's busy and they got this and they got schedules, and maybe there was this, maybe they had to talk about a habeas corpus and, something like, Now, if you got them coming in an hour to 2 late every time, every session, and you can show that that's a chronic thing, that's something. But 10, 11 minutes, yeah, I don't think they're going to give a damn.
Okay. But also, what do you think about not standing up for the judge when they walk in? When it says "all rise," I don't like to genuflect and pretend there's some kind of hotshot celebrity. So, me personally, I just keep sitting down. I make a silent statement. What do you think about that? Jeopardy of being held in contempt.
Well, I think it's great that you use the word genuflect, because that's what I used in Adventures in Legal Land. Were you channeling adventures
Very nice.
when you said that?
I am actually, and back in the day, this whole tradition of standing up is when the judge would enter a courtroom holding the Bible above their head, but they're no longer doing that, and I'm not going to applaud for somebody just because they have a Halloween dress on.
Yeah, I know in Arizona they don't give a damn. Occasionally there was, when I was in the Mesa City Court years ago, there was a clerk who had a particular dislike for me, and she started causing a scene, yelling at me to stand up. And the judge had to say, everyone just sit down. And they said, Mark, they knew me on a first name basis, some of them. And I said, no, it's fine. Just sit down. Some judges may threaten you with contempt. It's up to you how long, hey, I think it's fine. I have, I'm with you on that. I don't see any reason why we have to stand up, especially if it's on some kind of threat. But it depends, if you're a court watcher and you're trying to make a statement, hey, I don't know how long are you willing to spend a few hours in a can to make a point?
50-50 on that one, probably 70-30. I mean, if they threaten with contempt, yeah, I might give in a little bit. My time's more valuable and precious. But yeah, probably 70-30. And then also, speaking of that, also about removing the hat and removing the sunglasses off in the courtroom.
Well, I remember
What
that.
do you think about that?
I remember back. Well, the sunglasses shouldn't be a problem. I know that in New Hampshire years ago, Pete Eyre, I believe he was held in contempt and spent a night in jail for not taking a hat off. And look, you just got a power tripping lawyer. That's all it is. You got a guy who sought out a position of violent domination and prestige, that comes with it. And he's just on a power trip. So it depends, on you. If if you're gonna be able to, if you have enough of an audience and you think you're going to be able to convince a number of people of the violent nature of the system and how and how these people behave. Maybe it opens up some dialogue with them that you can discuss why the judge is so violent, and that it's a symptom of the system itself. It's not just because somebody got through or was voted in or was appointed who just has an anger management problem. The job, as I go through the psychological implications of the job, cause them to be that way. Heaven forbid you got a guy who's already unstable and gets in there. Then you got a Dick Noble on your hands.
Yes, I remember that show. All right, and then what's your opinion about courtrooms that want you to write express permission of the judge in order to video record?
Well, as I said before, and I'll be criticized for not understanding this either, since I don't understand nothing. The court rules generally allow, this is just not just for you, it's for everybody. They do allow recordings in most court proceedings. They leave the discretion ultimately to the judge, though, as I've mentioned before, because it could be a rape trial, it could be a trial involving a child. So it's understandable they're not going to want cameras. But for traffic and stuff like that, there's no legitimate reason that I have ever heard why we can't do that. It's unfortunate. It's just if you go in there and you secretly record, you can't use that you can't use that to help you because they'll prosecute you for that. But you can make it public if you're doing it as a court watcher. Hey, I'll go on record. I think it's great if you're as a court watcher and you want to expose these people for what they are. F them. Screw their stupid discretion. All right. Bring a camera in there. As long as you understand that you're making the choice as an adult and you're accepting the risk. I think I think more people should be going in and exposing these people for what they are.
I agree. I understand. I see. And then finally, the last question: is it really necessary to get our discovery request or any other future correspondence? Is it necessary to get that notarized, to have it witness verified during our signature process before we send it in as correspondence to the court?
No, a discovery request, I never notarize it. I don't even see a legal reason why anybody would notarize a discovery request. Why are you under the impression? What led you to believe that you were required to notarize it in the first place?
No, nothing in particular. I was just curious if it's absolutely, if there's some unspoken rule or something before you sign off and then send a PDF or the actual form.
No, you see, a discovery request is you're asking for evidence that the prosecution is using against you. And you're asking for Brady material and also in that exculpatory information, any information that can be used to impeach the prosecution's witness or witnesses. Okay. To notarize it, to prove that you signed it, the only time I would go is depending on if you have a prosecutor with a known history of being a prick, where you may want to have a certificate of mailing to prove that you actually mailed it. But beyond that, no, other than that, I wouldn't. No, I see no need whatsoever to notarize it.
Okay, and that would have also applied to miscellaneous requests, like, for example, the judge's employment contract with the city. No need for notarize, just send it in and boom.
No, yeah, unless there's a sunshine law or a freedom of information type of statute or regulation that it has to be that I'm not aware of, then I don't see any reason why you have to do that.
Excellent. All righty, Mark. Thank you so much. I will keep you posted, and I'm going to continue to listen to the show. Thank you.
Appreciate the call, Ted in Washington. We've got, I think, a Skype caller, so I don't know who you are, but you've been on the line for about 16 minutes. Let's see. We unmute you. All right, Skype caller. What's your name? Where are you calling from?
Mark, this is Tom from anywhere in the U.S. of A. I've called before.
Okay. Yeah, but when you call on Skype, I can't actually edit my. I guess if I had gone to law school, I would know that. I would probably know, how to run this particular software. But just because I'm just a guy, I'm just some schmuck from Long Island, and what do I know? But anyway, the point. Stupid joke there.
I've told you my story before. You heard my story, but I was wondering about Tom up in Michigan. He put a suit against the judge or the prosecutor for his time and stuff. Did you ever get back with him on that? Did he ever say anything about that? How he did on it?
No, I never heard anything like that, and I don't think anything is going to come of that anyway.
Okay. Well, my case is that I put in a Brady request back in January, and it's been sitting since then for a hearing, and I haven't had a hearing, and it's September now. Do you find that a little strange?
Now, this is definitely a criminal proceeding, right?
Yeah.
Okay. And when did they file the original complaint against you?
It's been quite some time, a couple years, 3-4 years, probably.
Years? Holy crap. Did you at any time during this request a continuance?
I've done a lot of things trying to get things straightened out. But also in January, I put the Brady request in with a deal to terminate my probation and a couple other things. And then again in April, I did it again, put in another Brady request, because maybe they didn't hear me the first time. And then I just put one in about a month ago, and they posted all three of them. They're all posted. And I'm just wondering, what are they doing? Shouldn't I have already heard a hearing?
Well, not only that, you probably should have filed a motion to dismiss for prosecutorial misconduct and also a motion in limine.
Mark, thanks. I did that. That was the one that I did just recently.
Okay.
Yes, I did.
But did you ever? I'm unclear. Did you ever request a continuance since this started?
Actually, I went the other way. I went and got one of those guys, henchmen of theirs, and had him go in for me. And he went in and they pushed him out the door and told him to keep his mouth shut and for me to go home. So we did. So I thought, well, that didn't work. So I'm going to go ahead and put in my Brady request. And I put it in there and they sat on that thing. And they sat on it, and they sat on it. So I put another one in, and they've been sitting on that one too. And then I finally put in this one with misconduct, exactly what you just said.
Okay, but I'm trying
So
to get
now I'm sitting a couple weeks on that.
Okay, but it could be. So you went and had one of their henchmen. Do you know if he entered any kind of waiver of speedy trial, such as going and asking for a continuance?
The guy that I hired is a pretty good guy, and he's really, he's in with the courts, and he can get almost anything done. This was the one time he couldn't get something done for me.
Oh, a lawyer. Oh, so
Yeah.
what he tried to do in court was defeated. So he's peddling false information. Oh, scam alert. Anyway, I shouldn't waste my time doing stupid jokes like that. If you can look in the docket, if he did not waive speedy trial rights, that may be something that I would file that if it's been if it's been more than most places with traffic, at least, except for New York. New York is 2 years, but most places it's 180 days. Here you're well.
They have never sat on anything that I've put in or anybody else that's put something in for me. They've never sat on over 30 days. Never. I've always gotten a hearing.
Wow. Well, you may be able to go to the clerk and get a hearing on the motion to dismiss for prosecutorial misconduct and get that calendared for a hearing so that the prosecutor can come in and defend not giving you the Brady material, not giving you the discovery. I mean, hey, I'm not a lawyer and I've never pretended to be a lawyer, but I'm pretty certain that any adult who can actually read knows that discovery is part of the criminal process. And that if you put in a request for discovery and the prosecution says "Aba fangul," that's a denial of a fair trial. Because again, I'm not a lawyer, but just understanding basic English, you can't defend yourself effectively or at all if they're not disclosing the information to you, and they are supposed to give that to you according to their own special rules. So that I would seek to get a hearing on the motion to dismiss for prosecutorial misconduct because they're not giving you the discovery, and I'm sure that there's some serious Brady violations there also. That's the way I would handle it.
Yeah. Well, I'm glad you said what you said because it made me happy because I was already there. I already did that. So what you said just ensured me that I did the right thing. So. I'll see where this goes, but I'm going to keep staying in touch with you. I can't really do anything because they got my hands so tied up that they've already threatened my life a couple of times and they've done a couple other things to me too. So there's not a whole lot I can do, but I can just sit and wait.
Well, you can get it calendared for a hearing, so that's something you can get done. Most courts have what's called motion day, and you can just get it calendared for a hearing on motion day. Just know that if they say it's the 9 o'clock docket, that doesn't mean you're going to be heard at 9 o'clock. I know that. I'm never heard at 9 o'clock when they say that. They hold me for last. They will typically do that. That's very common. That's anybody who challenges the orthodoxy. So if you if you just challenge assertions that the good old boy club, the lawyers. Okay, the ones who are actually officers and counselors of the court, because you have to be to practice law. If you go against the orthodoxy, of course, they're not going to want anyone in here that they're going to take you last. They always do that. Well,
could I write to you and have you punish these people for me? Because I don't know anybody else to punish them.
You can have them call the show.
Yeah.
Contrary to what this is an open. I am here. And I field calls all the time. When they come in on with dissent, it's I treat people with respect. I've been criticized very harshly for keeping people on too long, but yeah. So they haven't called the show.
Okay. All right. Well, thanks, Mark. You're doing a great job.
Appreciate the call. Keep in touch.
Okay. Bye.
Tom from anywhere in the United States. We've got another return call. We got a lot of calls here today. We got Mac in British Columbia. Welcome back.
Hey, Mark.
How you doing?
Thank you. I'm okay. Feeling a little low energy. Let me just plug headphones in and turn off my car. Can you hear me?
I can hear you pretty good.
Perfect. I'm doing all right. Couple of things here. I don't know if you got my Skype message picture I sent you. The Idaho court moved my date on me after I made plans to go down there for next week. So they pushed the hearing 3 months.
Did they
Did
give
you
any
see that
reason?
message for me?
Was there any reason why given?
Well, I sent you a picture. It says, let me pull that up again, the form that they sent me. Having read the motion and good cause appearing, it is hereby ordered that the trial set for September 20th, 2019 at 9:00 a.m. be moved to December 20th, 2019, 9 a.m. So
did the
you read the
prosecution
motion.
did the prosecution
Sorry?
file a motion to continue?
I didn't get any copy of that.
Well, it looks like you got
just-
some
it
ex parte
seems-
communication going on.
Sorry?
It looks like you have some ex parte communication going on with the prosecution and the judge. The prosecution is communicating with the judge, but not you. You didn't have an opportunity to counter that. Now, again, I'm not a lawyer. Don't ever claim to be one. But any half idiot knows that it is improper for one party to communicate with the judge without notifying the other party. So check the docket, see if there's anything in the docket, because the judge is obviously referring to something that came from, it seems obvious, from the prosecution. You didn't file
Well, hold on. The
motion,
top of this actually says Michael J. Sieb, Jerome County Prosecuting Attorney. It's an order to continue from the prosecutor. My bad. I'm not used to reading these documents. If you pull up my Skype message, there's a picture of it there.
Okay, I'll try to do that after the show. So has this been granted by the judge?
Well, the judge stamped the bottom.
Now, did you get a copy before the judge stamped it?
No. Oh.
Well, that's called ex parte communication. He's communicating with the judge. He's asking the judge to do something, and he's not giving you an opportunity to defend or object to that. That to normal people, that's not fair. That is not fair. The prosecution would have a stroke if you were communicating with the judge and the judge was granting your motions and you weren't providing them copies. It's just a matter of fundamental fairness. No law degree necessary to understand something like that. So I would, there's probably not anything that could be done about it. You could complain about ex parte communication. You could, I guess what I may do is file a motion to have the sanctions against the prosecution for filing a motion without providing you a copy.
Okay. But what does this mean? Having read the foregoing motion and good cause appearing.
Well, that's a standard legal thing, or that judges that are in judicial orders that just show that they've read the pleadings. Supposedly the pleadings of both sides, and good cause, and for because they agree with the grounds that they have provided proper grounds for the relief requested, they're going to go ahead and sign it.
So what the prosecution wanted is an order to continue. So
the prosecution must have filed. The prosecution must have filed a motion to continue. Didn't provide you a copy, and the judge signed off on it. Now, you may have a proposed order. So is there a judge's signature on it?
On the order?
Well, I'm trying. I wish I had my Skype on that I could just take a look at it. But is it signed by a judge, or is it just signed by a prosecutor?
Well, I don't have the the couple of documents they mailed me, but this one has the judge's signature, but it looks like it's a stamped signature. And on the bottom, it says Judge Jennifer Hammer, whatever her name
Okay,
is.
so
Hammer
whatever the
Winter.
name is, okay, so I would file, what I would do is I would file to have sanctions entered against the prosecution for filing a motion without providing you a copy.
Okay. How do I do that? Just write a letter to the court?
No, you can use one of my templates as a, to do that. You just strike out. You can delete most of the motion template and retitle it "Motion for Sanctions," and then in one, you could just do it in one page. Lay out that the prosecution filed a motion for a continuance and did not provide me a copy. That is ex parte communication, and therefore the prosecution should be sanctioned, because who knows what other communications the prosecution is having with the judge without providing a copy.
Okay. Now, I guess they haven't ruled on my motion to dismiss. I haven't heard on that. I asked for a discovery request. I haven't received that. What can I do about that? Or is that pretty normal, or I'm going to have to deal with that if I wind up going to this trial or hearing?
Well, it is fairly normal for prosecutors not to comply with discovery. The prosecutorial misconduct, according to Judge Kaczynski of the Ninth Circuit, I think it was the Ninth Circuit, Federal Court of Appeals, they're at epidemic levels. Prosecutorial misconduct is a very common thing. Prosecutors will withhold as much as they can get away with. And like I mentioned to, we're talking with Ted in Washington. Yeah, what I would do is file a motion to dismiss for prosecutorial misconduct and put in there, of course, how the prosecution's not complying with discovery. Okay.
Okay. Now, how about, like, I made plans to go down, in my life to go down to Idaho, and they're basically changed the date on me. Can I put that in there as being an undue burden or for myself?
What I would put that why I want, in getting the sanctions from the prosecution, because that was done without your knowledge and you didn't have an opportunity to object. So you could put it in there.
Okay.
I'm running out of time, so I've got to let you go.
Yeah.
But
I'll call back on another issue that happened
Sure.
in court, but I'll let you go. Thank you for taking my call.
All right.
Thanks, Mark.
No problem. We'll talk to you next Wednesday or next show. Gosh, I've got to take a few minutes here. I've got to get to the 9/11 stuff. So I appreciate everyone calling in. I'll get to I'll do my best to get to everybody. The 9/11 stuff. I guess I'm a little more than halfway through with the show, but that's one of the things I was going to lead off with here today. I lived through the Bush administration, as a lot of people listening to the show probably did also. I remember, like, a lot of stuff like it happened yesterday. I remember watching live the second plane hit. I remember watching as the first tower started to collapse. And I remember the first thing that I thought was, holy crap, they blew them up. Now, when you watch that, it just free fell. There's no way that was a pancake. That was not a pancake, especially when one of the buildings, there was so much of the top of the tower. The top, if it was an actual pancake because it was a structural failure, that the top of it would have been fairly intact when it hit the ground. Because as each floor get destroyed, there's a dissipation of energy. You still need more and more energy, and the energy is going to be dissipated because of friction. So the top part that was above where it started to collapse, that wouldn't have pancaked. And the official story right from the start, they found a passport. Oh, yeah. Okay, there was enough fire, there was enough heat that it did literally destroy and turn to dust. Yeah. 2 skyscrapers, but a passport was intact. So the whole official story from beginning to end was garbage. You get into, I don't have the time to get into all the details. But here you have over 3,000 people that are killed. 2 wars are launched. My gosh, could you imagine another country, another government launching a war to get one person? One, right? There was an invasion of Panama during, during the first Bush administration to get one guy. Really? You invade an entire country to get one guy? We're in the longest war in American history in Afghanistan. And even the part of the official story, it points to the Saudis. And of course, you got pictures of George Bush, which I've posted on the show, holding hands. They are not photoshopped. Holding hands with the queen or king of Saudi Arabia. You have the Bush administration that resisted an actual investigation into what happened. When they finally set up a commission, which should have been a criminal investigation, they weren't even first. Oh my gosh! You had Alexander Hayden. What the hell was that? Henry Kissinger, who was set up. So obviously, it was so obvious that the fix was in that they had to get rid of him and get somebody else to head it. But even when with this half-assed investigation that they did, Bush and Cheney refused to go under oath. What? Holy crap. Not only this, but they launched a war of aggression against Iraq, which had nothing to do with 9/11, even if you believe the official story. Every single excuse to invade Iraq has been debunked. And if you want a really in-depth investigation into that, I know it'll satisfy some here. An actual lawyer wrote it, Vincent Bugliosi, about the indictment of George Bush and others in his administration. And George Bush is on record. He laughed. He was making, oh gosh, he's such a vile piece of garbage. He was laughing at a fundraiser. It's recorded. He was on video laughing about weapons of mass destruction. Well, they got to be under here somewhere. The man launched a war of aggression where thousands and thousands and thousands of people were killed. This is why I talk about the ruling class. That's why I chose the thumbnail for this video. Why I chose that, because when you kill on a mass scale, when you are part of the ruling class, you do not get prosecuted. And people say, well, you just go after Trump. You don't criticize Obama. Do you have any idea how many times I criticized Obama and the Democrats because they refused to launch impeachment against George Bush and Dick Cheney and Alberto Gonzales? Remember the torture menu? Torture was okay. And one of the Bush flunkies is now sitting on the Supreme Court. Yes, Mr. Booth himself. Brett Kavanaugh. Brett Devil's Triangle Kavanaugh. Indefinite detention. This idea that you can launch 2 wars of aggression and not be subject to impeachment? Oh, and then there's that name that always comes up. I know this is the New York Post, but Robert Mueller was a week or so before 9/11 was made head of the FBI, knows that those were stolen passports that they put the pictures of. So they took pictures claiming that the hijackers, who, according to the official story, have to be dead, that they still used pictures of people who are alive. Refused. As far as I know, I haven't checked because there's so many other things go. But refused during his tenure as head of the FBI to update that. They weren't the right guys being shown as the so-called hijackers. Not only did the Bush administration do whatever they could get away with, it's pretty much everything, to impede and obstruct the investigation, but so did Robert Mueller. So in the Post article today, in October 2001, Mueller shut down the government's investigation after only 3 weeks and then took part in the Bush administration's campaign to block, obfuscate, and generally stop anything about Saudi Arabia from being released, added Promoli, now a plaintiff in the 9/11 lawsuit against Saudi Arabia. In fact, Mueller threw up roadblocks in the path of his own investigators working the 9/11 case while making it easier for Saudi suspects to escape questioning, multiple case agents told him. I mean, it's on and on about blocking things. Agents were called off from pursuing leads back to the kingdom's embassy in Washington, as well as its consulate in Los Angeles, where former FBI agent Stephen Moore headed a 9/11 task force looking into local contacts made by 2 other 15 Saudi hijackers. Moore testified in an affidavit for the 9/11 lawsuit. He concluded the diplomatic intelligence personnel of Saudi Arabia knowingly provided material support to 2 hijackers and facilitated the 9/11 plot. Yeah, he and his team were not allowed to interview them. And it's lie after lie after lie after lie after lie. They lied that they said that nobody could have imagined planes being used. Yet they had a drill for that weeks and months in advance. They knew that. They ignored warnings. It's just disgraceful. And then you have Congress and Obama not putting these that's how you look. They're all in on it. Obama just kept on doing the same damn things. They're all a part of the same club. You know, we're not members. What did George Collins say? It's one big club and we ain't in it. So on this anniversary of 9/11, what we should be looking at is the fact that we have a ruling class that can do literally whatever the hell they want. Just like Trump says, he could shoot somebody on Fifth Avenue and not lose a vote. Now, he may actually lose a vote, but he will never be held accountable. George Bush be held accountable for war crimes? Nope. Dick Cheney shot, I know he's responsible for a lot of deaths. He shot a man in the face when he was drinking and didn't even have a negligence charge. So yeah, that's what we should be remembering on 9/11, that even if the Bush administration wasn't behind it, they were doing their damnedest to cover it up. There is no question that they impeded and obstructed justice, that they impeded an investigation into that. There's absolutely no question at all. So even if we take a position, we don't know exactly because we don't know what happened. We don't have all the information because it's been covered up. What we do know, what was publicly said, is George Bush and Dick Cheney and the rest of the administration and Robert Mueller and John Ashcroft actively worked to block investigation. These are mass murderers. These are criminals. And because they're doing it as part of the ruling class, they will never, ever be held accountable. Now, anyway, I do want to get to the rest of the calls because we do have an awful lot of them and I'm running out of time here. So we have new caller, area code 609. You're live on the No State Project. What's your name? Where you calling from?
1 minute, Marcus. 1 minute. Let me spit something out. Sorry.
Well, I can come back.
Marcus, the blind man. Sorry about that. It's the blind man from New Jersey. How you doing?
Oh, wow. It's been a while. How are you doing?
I'm doing okay. I listen to the show every time it come on. Just didn't have no input. Just been learning. But I like to tell you, nothing happened with that case yet. But something else came up on it that I used your motion to dismiss on. Or in New Jersey, there are no more bail bondsmen. They have some kind of point system now when you get locked up. So being that all the bail bonds shut down, they sold, I guess, all their debts to debt collection agencies. So I was out on bail when they shut down, and then I got a letter saying I was being sued for $5,000. And I'm like, why? Because I was paying the bail bondsman off. I only owed them like $1,000 more out of $5,000. I used your motion to dismiss. I called in today to find out court date. they said, "You're the one who sent the motion to dismiss." Yeah, yes, it's been dismissed.
Hey, nice.
I didn't even never even had to go to court.
Nice. Wow, that's
Put
a
it in
rare
about
thing.
2.5, 3 weeks. Yeah.
Good job. Hey,
It's a blessing just to use that. Yeah.
Yeah.
As soon as I get the paperwork and stuff, because I'm upstate New York by Canada, but when I get back to Jersey, I'm going to go and get a copy, and I'll mail it in to you. And as far as what I used on it, I just put in that they, first of all, they overpassed the time on, being able to, sue me, because the most is 4 years, the least is 2 years. In this case, was from 2009. I also put in that the defendant suing me is not the defendant. I've never had no kind of contract with this lawyer or whoever he's working with, and also they had no proof of ownership, no paperwork from the original paperwork and the original contract, and they dismissed it.
Nice, great job, fantastic, congratulations. Sucks it
Thanks.
took so
Now,
long.
I have one more sorry about that. Go ahead. You finish, Mark.
I was just saying it sucks it took so long, but still, in the end, you got a total dismissal. That's fantastic. So, and I'm looking forward to seeing the documents. Great.
Oh, wait, let's not mix this up. This is not from the criminal one. This is from bail bonds, closing down, and the debt collection agency tried to get me to pay them, saying I owe them $5,000 now. Being all the bail bonds shut down, I guess they bought the debt up. So this is more a civil one I used it for.
Oh yeah, I understand, and that's great. I think it's fantastic.
Now, as far as the other one, you're not going to hear anything back. So I'm just living my life, man, and no fear. And whenever I answer to it, I'll answer to it, and I'm going to speak strong. I know your stuff pretty well, and I'm ready for them. But I have one question.
Okay.
The caller right before me, I heard him say that he put in a motion to dismiss, to terminate probation. So you can do that also?
Well, you can fight it, but I don't think that's what Tom or Mac were talking about.
Oh, okay. I thought he said that because on my original case that I, put in for the motion to dismiss, that's what I really ended up on. Drug court, I know you probably heard of drug court, is nothing but a probation. So they sentenced me to drug court. So I figured, hey, if I could do that, I'll put another motion in to try to do that too.
Yeah.
Just a thought. But as of now, I have the motion to dismiss in, I have the motion for Brady, and I have the motion for prosecutorial misconduct in. And, I made sure I got all the proof that I sent it in. I got all of that locked in the safe, so I have it. And I just wanted to call you in just to let you know your motion helped me in that civil matter. And I want to thank you so much.
I appreciate that. And good luck. Keep me in the loop. And when you hear something on the criminal side.
Definitely, I will. And I'm going to continue listening, and everybody listening, and keep sticking with Mark.
Appreciate it. Thanks for the call. Our resident blind man in New Jersey, glad for the call. Glad he was able to get that tossed out. I'm going to do my best to get through these next few calls. I think we have Minnesota. It's area code 651. You're live on the No State Project. What's your name? Where are you calling from?
My name is Brandon Joki, and I'm calling from North Branch, Minnesota.
All right. We don't need last names, but all right, Brandon from North Branch. Oh, it's okay. Just for you and anyone else who may call. We just need a first name, or okay. Just name where you're calling from first. Yeah. So
all right.
What's going on?
Well, tomorrow is my settlement conference and for my pre-trial, so I'm kind of stoked about that. Going to go in there with a guilty plea, unsigned, and I'm going to ask the prosecutor, I'm ready to sign this guilty plea. I just need to ask you one question, and the question will be, what evidence do you have of jurisdiction?
Well, I would do it a little different. What I like to do is first ask them so we know how they're operating and we could use that against them. You have to know exactly what their claim is to be able to then challenge it. All right. So I like to ask them, so you guys are operating under the presumption that just because I'm physically in Minnesota, the laws apply, and that creates and gives jurisdiction over me. And when they say, well, yes, then you can start saying, oh, okay, well, what evidence do you do you have that actually shows that that's true? What witness do you rely on that you will call at trial to prove that beyond a reasonable doubt?
Yeah, and then of course there is no evidence, and I never got Brady material or anything like that. They got their little discovery, but I read through the discovery and didn't see any evidence in there. Just quoting laws and legal platitudes and whatnot. So yeah, there won't be any evidence, and so then in good faith, then you should dismiss this case.
Well, you want to make sure you're following up correctly on the questions. Before I would even I wouldn't mention the intention to plead guilty right off the bat.
Oh, okay.
I would, because if you're trying to get this resolved, it's a pretrial conference there. You're trying to get first get some leverage, and if you get resistance to that, then I bring that out. So if they're saying things like, hey, I don't need to prove that, and they go like, "I'm a phone the judge won't force me to," then I said, well, look, sir, with all due respect, I'm more than happy to plead guilty and get this off the docket if you have this evidence. If you actually have this, this proof, then then you can. If he refuses, then now I would bring it in front of the judge if possible that day and argue prosecutorial misconduct and serious bad faith, because you're willing to plead guilty. And he's now, if he has this evidence, he's actually arguing he doesn't need it. I mean, even the resident troll here is going to, he sometimes says, well, yeah, you have to have evidence. So for jurisdiction, you have to have prima facie before trial, and you have to have beyond a reasonable, evidence to prove beyond a reasonable doubt at trial. So two different, two different burdens of proof depending on where you are. So.
But they're all their burden of proof, not mine.
It is.
Yeah, and they don't have any evidence of jurisdiction. Then anything after that doesn't matter. It doesn't matter what the charge is, the allegation, because they can't prove jurisdiction. They just try to railroad over it every time.
Yeah. Well, they want to either lie and say it's a trial issue only, which it's not. Then the judge will typically want to insist there is jurisdiction, and that's why we want to, question him or objection. Is that because you say so, or because the prosecution's evidence does? They don't want to address the issue head on because the prosecution doesn't have the evidence, which is why even Supreme Court justices, not court reporters, Supreme Court justices have actually argued to me personally, as well as county attorneys, that the evidence proving that the laws apply and that there's jurisdiction is they've prosecuted other people. Now, that's a Supreme Court Chief Justice, not a court reporter. So maybe if the Supreme Court Chief Justice had taken counsel from court reporters, maybe they have a better answer. I don't know. I'm spitballing here, but
so I'm going to I'll have something on appeal. I mean, it sounds like it'll probably go to trial then next week on the 16th, and I'll probably just have to appeal it because I don't think that this judge would have any honor. No,
but they don't. But they're criminals. But you have to prep for the cross-examination. Okay, prep like yes, you want to get your appealable issues if you're going to have to appeal. And through the cross-examination, you're going to get your best issue for appeal, and that's a denial of effective cross. This is why, I'm loath to say this again because I'm getting tired of these comments. But you put the police officer, you ask him, did you determine on your own that just because I'm physically in Minnesota, that the laws applied and that you had jurisdiction and probable cause to stop me? Now you're just getting him to restate what led him to believe that at the stop.
Yeah.
And then when you follow that question up, well, what facts did you rely on? Okay. The court reporter's head explodes. Okay. And
Yeah.
And the prosecutor will say objection calls for legal conclusion. The witness may not testify. Now, the question, as any half idiot knows, didn't ask for a legal conclusion. You're asking for the facts. His determination was made that he made at the stop and what he just said on cross-examination. You're just going and asking him to support his prior statement. Now, again, the court reporter is having a stroke at this point because they figure you're such a complete and utter idiot that why can't you understand what they're saying? But basic principles of logic and just being rational adults, when you ask somebody for the facts their claim was based on and their prior statement was based on, it's not asking for a legal conclusion. No. So the judge reflexively, right, you're asking for the facts that his claim was based on. Perfectly legitimate question. But the judge will deny you effective cross and not allow you to get an answer to that question. So that is going to be
the witness.
Yeah, he's going to say the witness. Well, he's taking an off-point objection. It's got nothing to do with the question you just asked. And the judge buys it. So now you've got what I believe is collusion between the judge and prosecutor, because the judge, if he had any semblance of fairness that he was trying to stick to, would say, Mr. Prosecutor, that's not the question he asked. But they don't do that. Maybe they're taking, maybe they say, hold on. Let me ask the court reporter if I should sustain or deny that or overrule that objection.
Yeah, right.
Let me ask the court reporter, Miss, stop typing. What do you think? What's your opinion on this? Should I deny or overrule or accept that objection or not? So, but that's going to be your reversible error if the reviewing court is going to actually address it. So, I'm going to try to
like you said, the Supreme Court even is sounds like they're fallible too. I was hoping that we'd get some better minded judges up in that level, but
no,
doesn't sound like that might happen.
No.
Either.
Well, they have. Look, for a lot of things, they have an agenda. For murder, stuff like that, unless if it just involves the plebes, they'll stick to the rules. Tax case, they're totally out the window. I've watched it. I've read enough of these cases. I've been personally involved with this stuff. I may not have all the expertise of your average court reporter, but yeah, I've been through this quite a few times, and I've spoken to directly in hearings in and out, court and administrative. I've spoken to enough of these people. I've questioned them. I've had them on the show. If there was actual evidence to prove that these laws apply, they would just present it, and it's not. Yeah. It is not a valid argument to say that only the judge is not making these claims. The judge has to make his decisions based. Again, I'm not a lawyer. I'm not even a court reporter, but I'm pretty familiar with the system. And I believe that the Supreme Court and of the feds and the states have all ruled pretty much unanimously for over 200 years. The judge's decisions have to be based on the record. That is some basic fundamental stuff. If the judge is going to make a determination of legal claim A, then that has to come from one of the participants. That has to come from one of the parties. To just pull it out of thin air because I'm the only one who can determine claim A. Come on, give me a break.
What a joke.
Well, this is something that we have to deal with. It's unfortunate. Instead of just calling into the show and addressing me in real time, like you are, or like other, or critics have done, and just spewing crap on YouTube. So, I got to go. I'm going to try to get one more call though.
Appreciate it so much, Mark.
Yeah, keep in touch. Let me know what happens.
I will.
All right.
Thank you.
All right. And Brandon, definitely prep for that cross-examination, regardless of what somebody says. The actual practical application of in a fair trial of their rules and due process, if a cop has made, or a tax agent has made a legal claim, they have the burden of proving that, and it does not relieve them of their burden of proof to consistently say on YouTube, only the judge may have the ultimate determination. Only a judge in a bench trial can say whether somebody committed murder. That doesn't stop the police officer from accusing you. That does not stop a police officer from making a determination of probable cause. They still have to prove it so that the judge makes the ultimate determination. I mean, oh, good Lord, woman, give it a break. Just call the show if you're a critic. I'm going to try to take one last call because I'm pretty much out of time. So we got to be quick. Lucas in Philadelphia, Mississippi.
Yes, sir, Mark. How you doing today?
I'm doing pretty good. How you doing?
Doing all right. I was going to give you an update on my court. They moved it from the 4th, which was this past Wednesday, to next Wednesday.
Oh, jeez. Any reason given?
No, sir. None was given, and the notice was sent in the mail. I did have somebody sitting there at the court to make for sure that, you know, if they did have court, because I don't trust very much that they send, and there was no judge's signature, no court seal. It looked like a court document, but it could easily be passed off as, no, this ain't ours. So they didn't have court, so it will be on the 18th. And I've got your email where you had sent back that you did get the copy of my ticket from whenever I got it from the judge.
Oh, yeah, I got to get that posted. That's one of the things I got to get posted. I do have the ticket with the notes. And so for those who didn't hear or don't remember, he has a ticket, a copy of the front and back of the original ticket that the police officer filed with the court, and there's notes on there to the judge. And they are not on his ticket. So ex parte communication on the part of the police officer. Nice of him to do that. Should be dismissed on that alone. So have you filed to have it dismissed based on that ex parte communication?
They will not accept no paperwork. None.
What? Oh, so they're saying they're not going to accept paperwork until the day of trial?
If the judge decides to take it then.
Oh my gosh. Well, I may not be as look, that is obviously a denial of due process because you're supposed to have a due process right to a fair trial to be able to effectively defend yourself. And pretrial motions are a well-established part of legal procedure in court. It's what you use to defend yourself, and to not allow you to file any paperwork to defend yourself sounds to me like it's a pretty substantial due process violation. So unfortunately, without taking money out of your pocket and filing in the higher court against them, you may not be able to get that particular issue heard unless you have to appeal it.
I'm going to try and carry it as far as I can because I know it's not right. And then we've had a lot of corruption lately. I was meaning to take a picture of the newspaper and email it to you, and this way you could pull it up. We've had a lot of our court officials, the little clerks and everything, doctoring the books, and there's been several. I can't even keep count anymore of how many that's done been charged with embezzlement.
You know, that's something I would say most government employees, at least the mid and upper management, could be prosecuted pretty heavily for. I mean, I reported not too long ago that there were police officers with time card fraud. They actually got charged. So
we had that. It's been a couple years back. We did have that. They was checking the books because our city decided that they wanted to write in the books that they had been repairing a bridge that hasn't been up to code in over 40 years. And they got shut down, and before they could get the money to fix the bridge right, we're going to see these books. That's where they started getting caught.
Oh, well, hopefully some people go to prison. I like to see that. I'm totally out of time. I appreciate the call. Look for, yes, send me that newspaper, and I'll should be able to get everything posted here within the next week. And if I don't talk to you before the next trial date, I wish you luck. And remember, keep the burden of proof on them and ask good leading questions. All right.
Yes, sir. Thank you.
Appreciate the call. I do have to mention, of course, about, with the whole thing with 9/11 and George Bush, being part of the ruling class, not being prosecuted. Remember, no one held accountable yet for the Jeffrey Epstein case. Prince Andrew, George, what's his name? Bill Clinton and Bill Richardson and Alan Dershowitz and Donald Trump. Still, but I haven't seen any new information, and maybe they're just trying to, this whole Sharpie Gate thing and things like that, just trying to get the Epstein case buried. Never forget. We cannot forget about the Epstein case. So appreciate everyone tuning in today. We had a lot of calls. That was good. Anyone I did miss, I will not be live Saturday, but I will be live Wednesday. And if you do disagree with what I say on the show, just call the show. That's the best way to get in touch and embarrass me. If I am giving false information and you can prove that, go ahead, just give me a call. You'd be pretty hard pressed to find a critic that called a show that I was not professional to, because I usually went above and beyond. And the only time was when someone got really abusive, like the infamous Wit in Arizona. So I'm not going to listen to excuses. You have dissent, call the broadcast, and I'll even record it off and then post it as a podcast, because it still goes out on lrn.fm. So I'm willing to do a private recording also, and then post that. So if there is an issue, if there is dissent, you're more than welcome, and I will address it, like I did on this show extensively, although, it's like talk. Anyway, I won't be live on Saturday, but I will be back Wednesday. And starting on that next Wednesday show, I will be doing the 2 regular shows every single week. So I appreciate everyone tuning in. If you want to help support the show, it's 218-632. I did it. I got through the first part without doing that. It's markstevens.sells. It's selz.com, markstevens.sells.com, and markstevens.net. And also, if you are looking to improve your arguing skills, recognizing BS, being able to more effectively defend yourself in court, I have scripts and templates available. And of course, a book, Government Indicted, that you can get. Appreciate everyone tuning in. Until next Wednesday's live broadcast. Salud.